So when you are in counsel defending your client, a defendant in a criminal proceeding, there are certain things that you must take into consideration, certain things you must do. One, you must be able to have the contents of the case file. The contents of the case file. You know, in real life, like if you're being talked about, you're hearing it theoretically, you may not know how it plays out in real life. In real life, you could have a situation whereby A was arrested the day before yesterday, and all efforts were being made to trace where he was. Maybe by the time later part of yesterday, you found out he was in so police station. And you go there to negotiate the price. Oh, counsel, don't worry, come back tomorrow. We'll listen all those police antics. You end up not having your clients released to you on that very day. Maybe the next day, they've arraigned him. They say, come to court one. The matter is overnight. You go to court, there, you are armless. And you don't even have a clue of what you're going to do. Maybe the next thing that you may be able to do is like, while you're in court, they call up and they say, clerk of court, please, can I have the charge sheet? You're seeing the charge sheet for the first time. And you're reading it for the first time. And at times you're seeing tomorrow, you think it's tomato. And your head is turning. You're not even understanding anything. Most of the time, that's what you meet in real life. For a lawyer who knows his onions or who is ready to learn, what do you do in such instance? You quickly glance at the charge. Actually, it's a bearable offense. He said, your worship, you narrate all your attempts to locate your client, and it was denied. In other words, you underscore the point that my client doesn't even know why he was arrested. I never see him seeing him for the first time. The only briefing I had was, lawyer, please come, they are taking me to court. I don't even know what the offense is all about. I've not heard from him. But your worship, since the offense is bearable, the only thing I can do at that moment is to do what? Apply for his bail. And while applying for his bail, also make an application for the contents of the case file to be duplicated and given to you, for you to properly study it to enable you to defend your client effectively. So this is a practical aspect of how to commence defending your client. Now, at times too, the question may arise, if the contents are duplicated, who pays? Who pays? Even if the law says prescription will pay, what's the business of prescription paying for you? So you just make arrangement. Even if they say you are the one to pay, just make arrangement, have it done. Right. So that at least after you have gone home that very day, what you have from your expertise as a lawyer, you have been able to get him on bail. Now let's look at another scenario. Maybe a scenario where you went to the police station, he was granted, but he came back home, and he has been served with arraignment notice. Most of the times, arraignment notice will command him to attend court on so day on a charge of stealing, blah blah blah. But the main charge will not be attached, so you will not even see the charge. Assuming it's a charge that you may want to raise objection to, you only see it when you get to the court. Right. At that point in time, what you simply do, because you are not fully equipped, interview your 400 level lesson. That's the only way it comes in. Interview your client. Find out what he did. Find out, as you're listening to him, you're also thinking of possibility of defenses available to him. Possibility of defenses available to him. Okay, now they said they saw you, broke you, stay safe, so you not me. Okay, where were you? What are you trying to establish? Alibi. You're trying to establish alibi. Right. You know that now. Now, when he says, I was at my sister's house at so place, the next question you as counsel, because question will prompt more questions. answers will prompt more questions. You now ask him, did you tell the police you were not even at the crime scene? He said yes. Did you tell police where you were? Let's assume he answered yes. And then you note it. One, because you have noticed a defect. Who will tell me what the defect is? I am the alibi now. What is the defense? What is the defect there? I'm not saying defense. You have noticed a defense and a defect. What is the defect? He has told you, I told the police I was at my sister's house, I wasn't there. And then the police said they are nothing, so the police didn't do nothing good. What is the defect?
And if somebody makes such statement that he was at so place, it is the duty of the police to go with him to that particular.
Investigate alibi at the quickest time, at that very time that the information is still hot. Investigate alibi. If the alibi was investigated, you mark it defense alibi. Right. And then you also take him through the charge, trying to bring out defenses. They say you stole. Was anything found with you? Let's say, for instance, he said, yes, something was found with me. Somebody follow up. What will be a follow-up question? Maybe what is being looked for was found with him. What else will you ask him? Come on, obey the rule now. Raise your hand and talk to me. What next will you do? Is it only Saturday? Answering questions on a Tuesday? Any other person?
Sir, if he tells that something was found, you ask him what was that?
No, I said the thing stolen was found with him. What will you ask him? What will be your reaction? This mock now, go ahead, stand up. What will be your next question?
Sir, you will ask him how he got.
Not me, you now. As you are now the lawyer. You are the lawyer to the suspect, okay?
The stolen item found with you, ask him how did you get it?
You are asking him how he got it. Okay, let's say he said he bought it. Continue. What next question will you ask? Why would you ask him those questions?
To know if the worth of the goods he got from that person is actually the price value of that.
So by that, what were you trying to establish? Okay, somebody take over from her.
If the vendor bought the item at normal market price at that time, it can be bought the charge of
the charge is still no. Don't put your own charge. Okay?
It can be bought if it's receiving stolen property.
No, there's no receiving stolen property in the charge. Yeah, I told you I bought it. So, assuming he even bought it, he bought it from a private person, not from the market part. What will be your reaction? What will you tell him?
Guilty knowledge if the price is under.
You're talking to, okay, I'm the person now, talk to me. So what will you tell me? Let's say the value of the phone is 700,000, and I'm telling you I bought it at 120,000. The way you're looking at me, you're feeding me.
You should be able to know that it was lawfully obtained.
You're talking to me and your client talk to me. You see, that's what Mom does for you. He opens you up. Talk to me. You're addressing me. And I'll be answering. Then, you know, some of these things we read, those cases, it takes time to mold those parts. At times to get recalcitrant clients. You may have a client who can pay, but he never tell you the truth. All right. So let's make progress. What are we trying to do? Fact finding. As you're doing your fact finding, you're also racking your brain to find defenses. And when you have finally obtained the case file, the contents of the file, the recourse file now, what you do, you hold another session. As you're talking, you're trying to see, you have established some defense. You're trying to see how can I crack the case of the prosecution. Because the documents you have now contains all the state all the statement of witnesses made against your client. You take them one by one. Mr. A said this against you. What do you have to say? He thought, if you at times you come to my chambers and see where we do it, you may even think we are at times we are quarreling. I want just everybody be serious, right? You have to win. You maybe next time if you lose, no allowance. You know that thing. Everybody gets serious, right? So you now look at the facts again. Try to see if you can crack the case of the prosecution. And by cracking the case of the prosecution, what will you be looking at? If you want to crack the case of the prosecution, what will you be looking at? You know, you raised up your hand last time, I didn't see, but I saw you now. So, what will you do? You want to destroy the case of the prosecution while you're talking to your client. What will you do? How do you go about it?
Sir, I'll have to ask how the property got into my client's hands. And then I'm going to ask him if he's aware of the original value, like the market value of
No, you are done with him now. In that interview, I say, while you're gathering the facts, the next thing in the back of your mind is destruction of the prosecution's case. How do you demolish prosecution's case?
Okay, sir. I'm going to present evidence.
No, at the interview stage, you are not presenting anything. Which evidence now need to present? Whose evidence? Okay.
I'll bring the content of the file vis-a-vis what I'm gathering from the evidence to equip me so as to defend me properly in the court.
We are still being theoretical.
You look for any inconsistency in the case file and what your client is telling you.
You can't find inconsistency in the case file. How will you find it?
Like the difference between what contains the case file and what your client is telling you. So if what your client
We are. Be specific. You are comparing what your client said with what is contained in his statement to the police. It's a judicial statement. Call it name. I'm getting you now, right? Just mention the document you're looking at. Let's say, for instance, that statement said that your client made a confessional statement. How would you go about it?
you check whether the confessional statement is voluntary or was obtained under duress.
Okay.
Yes. Then you also ask the client whether the signature contained in the statement, the confessional statement, was written by him. You ask him whether the language written.
You know, mere denial will not exculpate him. If he comes and says, I didn't sign this, that does not fall under oppressive measures. How to debunk through oppressive measures. That will be another year. The court will say, just go ahead and admit it. What next will you do? You still have the case file. What next? Somebody raise hand around this place. Okay, you now. What next will you do? Okay, sir, another one.
You can raise questions that the prosecution might likely raise in court and ask him questions.
No, we are trying to demolish prosecution's case now. Looking at the case file we are studying. You know, I mentioned prosecution must have witnesses. Maybe they have witness A, B, C. A, B, C all made statement to the police, and they're in that case file. What will you do with them at the stage of preparation? What will you do with those statements?
I think that when you need to consider the statement by the and check if there are contradictions with what you have said.
Assuming there is none. You may find, but if you don't, contradiction between who is who and who.
The witnesses, if there are like three witnesses, you consider their statements, the three persons you.
Okay, whether they conflicted on any fundamental issue, not just any other conflict. Because as a human being, now there may be conflict. But if that conflict is on fundamental ground, that is when it becomes material. Now, what next do you do with those statements in your hand? What next do you do? Can't you ask your client the identity of these people? Can't you ask him, have you ever had scuffles with any of them? Do you have life issues with any of them? Ask him, is there any reason you think any of them will come and testify against you? Why would they write statement and and they are willing to come to court to testify against you, is there anything that has happened between any of you, between you and A, B, or C, or three of them? These are areas that you can get information to debunk. And at times, if there is none, maybe the person was caught in the very act, you still try your best as a lawyer. Do you understand? When you are trying your best as a lawyer, you are not maybe actually say, my client didn't do it. You are trying to see if you can secure victory on technical grounds. Right? Now, you look at this statement and find out this kind of offense, does it require corroboration? Can we say that the evidence of A has been corroborated, or B, there is corroboration? You notice there is none, you mark it. By law, it is required, but it's not there, you mark it. Now, this person, this ABC, you're reading their statement apart from conflict. Did any of them witness the incident, or is it hearsay? Fundamental. If in the end it is John that told A, the same John told B, and B now told C, how can there's nothing else? Yes. Are you following? You must learn to sit down, analyze these statements if you must make headway. Right. Then there are a lot of things you can also consider. Like I told you, this course is ingrained in the law of evidence. Now you now talk about evidence. What kind of evidence can my client now give? How would my client debunk all the pieces of evidence against him? You must think of that kind of evidence. What if we call a witness? You know, in a criminal matter, a defendant just can't wake up and call a witness. Let's do a little exercise. Let's say Z wants to testify on behalf of the defendant. Who is Z now? Let me have a Z counsel. Fast. 2 persons, stand up. 2 persons. Z counsel, Z. Okay. Now Z, the allegation, let's have a suspect. Let's have a defendant. Who is the defendant? Fast. Let's have a defendant. You don't want to be a defendant. It's a legal government. See the defendant. It looks like, no, sorry. Okay, our defendant is very a gentleman, very tight. Right. Now, defendant, the allegation against you was that you stole a bicycle. Now, you can't stay, I know you. Now, this man is set to testify for you. I'm the judge. Right. Conduct your matter. Bring him, lead him, let him give evidence to exculpate this person. Let's see how he goes. Lead him.
Okay. My lord. Okay. Please.
His evidence, you may forget protocols. His evidence, he's coming to tell us that this person did not steal any bicycle. Right. You're presenting it now. Let me have a prosecuting counsel. Let me have a prosecuting get up. All right. Okay. Go on.
Please, can you tell this honorable court if you found any bicycle in the custody of Mr. Anjogo?
You are going to allow him to answer? Okay. What is your question? Let me hear you. It's a leading question. Counsel, rephrase your question.
Let me ask you, did you see any bicycle with him?
No. See, he has introduced himself. I'm Mr. So. Look at what I do. Do you know the defendant in the dock? He says you know him. Can you cast your mind back to maybe the date of the charge, or in respect of the charge of stealing against this man? Do you have anything to tell the court? So that the person will not be leading. All right, proceed.
Introduce yourself. Who are you, sir?
I remain Emmanuel.
I seem like a policeman, so I doesn't become a friend.
Please, sir, can you take this on the court? Can you introduce yourself, please, on the court?
My name is Emmanuel. I live at Susan, number 3 Emmanuel Avenue. off Maraba, Aba.
Okay, please, do you know the defendant at the door?
Yes,
Do you know
of
him?
course, I know him.
Who is he to you?
He is.
Hold on, just go on.
He is my church member.
Okay.
For how long have you
Prosecution, you're taking notice. He is a church member.
For how long has he been your church member? For how long?
Well, I started knowing him the very day I saw him in the church. Because there is no record of church being handed over to me.
Witness, you're not getting the question. For how long have you?
You have been antagonistic to your client. Are we learning something here? As far as, excuse me, as far as this proceeding is concerned, you are his best friend. You are his last hope. Make him feel at home. Don't ask him any questions that will backfire. If I were you, do you know this person? He is standing charge trial for you read the charge. Do you know anything you can tell the court about this? You're playing safe.
Okay, can you introduce yourself to the court?
Ibe Emmanuel is my name. I live at number 3 Avenue off 44 Brand Street, Aba.
Alright. Do you know the defendant at the door? Do you know him?
He is my cousin.
He's your cousin?
Yes.
I know him.
Yes, I know
Don't put him into trouble.
I know him.
Alright, okay. You have a charge before this honorable court on the offense of stealing, and I want you to tell this honorable court if you know anything about this particular incident that happened on the 25th of August 2025.
Sincerely speaking, I do not know anything about stealing.
Case has ended. Did you see? So in this case scenario, see, even the lesson is for everyone. Hold on. In this case scenario, he has asked you may not even, it was just, this man is standing trial for so. Is there anything you know about it? Is there anything you can tell the court? And he start talking. But once he said, I do not know, you have brought a witness that is not useful to your case. Right. Remember, you are here to tell the court that he did not steal any bicycle. Okay. Do it sharp. Let's see. I want to see what the prosecution will do.
Yes.
Okay, just answer now. Let's see what your answer will be.
Yes, I know him, like I said earlier.
Go straight to the one brought him to court.
He never stole any bicycle from any person.
Please, are you sure of what you are saying now?
You can't ask your client, are you sure? It means you didn't prepare him. Okay, let's stop so far. He didn't steal anybody's bicycle. Cross-examine him.
For a witness, you stated that the defendant in this court is your church member.
Yes.
Can you tell us the name of the church?
The name of church is Presence Assembly.
Okay, for how long do you know him as a member of the church?
I am not the one who keeps the record of the church. I only saw.
No, you don't have to be antagonistic. The question is straight. Your answer must be straight. I've known him for 3 days, I've known him for 3 years.
I know him just 1 year from now, 12 calendar months.
For 1 year?
Yes.
Is he having any position in the church?
Sorry?
Is he holding any position in the church?
Yes, of course.
Are you also having any position in the church?
Yes, I do.
Okay, I'm done.
Okay, you're done. Just hold on. Just sit down. Let me ask him a couple of questions. Now, in this kind of cross-examination, don't look for flowery language. Don't look for flowery questions. Look for questions that will be straight, attack, and destroy his evidence. He has told you he didn't steal anybody's bicycle. He's my church member. What comes into your mind? He's laying foundation for this man's good character. Am I right? Yes. Go back to evidence. So we are coming to that. Then the next thing I want to ask you, did you make a statement to the police?
Yes, of course I do.
You made a statement to the police. Were you there when the bicycle was stolen?
I wasn't there.
You were not there when the bicycle was stolen. Compare these two questions now. You see the second question has got it. Now let's take an instance where he did not make statement to the police. Answer me now. Did you make statement to the police?
I did not.
Prosecutor, what do you have to say for that? The witness did not make statement to the police. What would you can see that now. What is the effect? What is the effect? What is the effect?
The effect is that he only come to the court to defend his church member.
No, I'm talking about the legal effect. Somebody who failed to make statement to the police, can the person come to court to give evidence? Do a little research. Give me the answer by Friday. Give me the answer. Now, I know why I brought out that. I will close it on Friday. And now another thing you also need to do, you now after this thing, you have studied the case file, you have been able to look at the cases against him, you have looked at his own case. What next you have to do is court tutoring. You have to tutor him pertaining to the court you be attending. First of all, you're a defendant. Every time the matter is adjourned, you must be present in court. Do you understand? Then secondly, on the first day we will go to court, you bring somebody who is a reasonable person in the society, who will sign surety for you. Are you following me? And then you educate him, let him know that if you abscond, your bail may be revoked and your surety may be arrested or made to forfeit the bond. Are you now learning something now? Right, so court tutoring is very important. Then you also tutor him on the right to what? Election. When the matter is called up, they will ask you, you want your matter to be tried here or at the high court? They got that one, I marked it, I take it for them. Right. So court tutoring, a lot of things can come into that. Another part of court tutoring is temper. How to manage your temper. If the person is somebody that is hot temper, say, look, if you come there, one, first of all, dress nicely. Do you know that appearance matters? Right. Why? Because the court observes your demeanor. We talk about appearance and we talk about demeanor. When you appear responsible, you put doubt in the mind of the court. How can they say that this gentleman is true? The court will not be saying it loud, but that's what will be in the mind of the court. How could this person? I mean, it's difficult for me to believe he did it. Do you understand? Your appearance alone has done part of the job for you. And your demeanor, your kindness. No, how you answer a question politely. Mind you, when you're answering the question in court, you're talking to the judge. You're not talking to the opponent. You're not talking to the opponent's lawyer. You're talking to the judge. So you don't have to talk to the judge rudely. You have to talk to the judge with the... There's one mistake you make. Don't let your witness, your president, be in charge. Always be in charge as a lawyer. Don't let the witness be in charge. At times you can, even though the evidence doesn't allow you to ask a last question, there's a way you can politely throw one insult, demoralize him a bit, and then you move on. About the manner, then you as a lawyer, don't remind your client or don't insist on counterproductive rights. Don't insist on counterproductive rights. What are those counterproductive rights? You tell your client you have a right to remain silent. You remain silent forever. It's counterproductive. When that right arises, that right arises not at the stage of plea. Are you following me? Not at the stage of plea. At the stage of plea, you may be mute. Mute most at time may be an act of God. But if he decides to be mute, then the court will want to find out, is it a medical issue? Before finding out, now you'll be somewhere cooling off for the court to find out. Right? So disabuse his mind from all those negative rights, those counterproductive rights. And then the right to remain silent is when you're called on to defend yourself. And when you're remaining silent, it means three things. One, it means admission. Secondly, to remain silent means I am relying on the case of the prosecution. The third one, to remain silent may even be you are slighting the court or you have no defense. So you discover that from all the what this thing that right it does is not a right worth having. So make sure you don't go educating your client on those non-positive rights. Then also ask your client, have you gone to jail before? Have you been tried before? So that you are want to guide against possibility of what? Double jeopardy. Especially if you are defending a career criminal or a chronic criminal. Right. And you know one funny thing, they will tell you in law school, you cannot as refuse to handle a matter and just because the person is a criminal. Right. You can't do that. I remember once a judge wanted to impose a case on me. You know you can do pro bono. I politely declined, but the judge has a right to impose somebody on you to defend. Why? Because right to counsel. And right to counsel of your choice, at times the person doesn't have choice. Choice means you have money now to pay. Right. So when the judge, when the court appoints a counsel for you, it becomes a counsel of your choice. Are you following me? Right. So the court can impose a counsel, impose a matter, a criminal matter on a counsel. Right. So there are a lot of things that you need to consider. Now you also plan of, you think of the bail. If peradventure the court decides to grant bail and the court wants us to produce to get a surety who has tax clearance, you ask your client, do you have somebody who has tax clearance who can come to court armed with tax clearance? Do you understand? So that he can be able to go